Mr. Benson.
My Lord, I was intending to invite the Court's attention to various parts of the Deputy District Judge's judgment, but that's probably not necessary because it's accepted that the Deputy District Judge erred in applying Section 11(1)(a) rather than the extended covenant, and therefore asked the wrong question. But he did make findings of fact, which in our respectful submission can't be challenged. They are summarised in Lord Justice Lewison's judgment.
That's a helpful way of doing it, thank you.
At page 380. And we would simply say this. Lord Justice Lewison, as it's acknowledged, asked the correct questions. Mm-hmm. If the paved area was an essential means of access to the building, which in our respectful submission can't be contested, mm-hmm. Then it's very difficult to see how the paved area was not the exterior to a part of that building when that part of the building is the front door and the hallway. And we respectfully suggest there's no sound reason, therefore, to interfere with Lord Justice Lewison's assessment.
There's a difference, isn't there, between the exterior of the building and something that's outside the building, but within the curtilage? And that's a question of law.
Yes.
I mean, the pavement you came into this building from is an essential part of the access to this building, but I don't think anyone would say it was part of the exterior of the building, would they? I mean, it's...
Well, Lord Justice Lewison acknowledged the pavement was not... the pavement itself was not an exterior part of the building, because he said the pavement cannot amount to a part of the building. But is it an exterior of part of the building?
But I don't think anyone would call it part of the exterior of the hallway of this building.
Well, that's what Lord Justice Lewison concluded.
I mean, if it's not part of the exterior of the building, then a fortiori, it's not part of the exterior of part of it.
Yeah. Sounds logical.
I can't take the submission any further.
You say one has to adopt a pragmatic and practical view of things rather than too linguistic a view.
Can I just deal with, briefly if I may, the question of, revisiting briefly, the question of possession and control. Cases demonstrate that if the landlord retains possession and control, that no notice of an actionable defect or a defect falling within the covenant is required. But that doesn't mean to say, in our respectful submission, that if the landlord is not in possession and control, that notice is required. And that's because in our submission, it depends on the means of acquiring the knowledge. And that's not necessarily dependent on possession and control. And it's exemplified in a case where the defect falls within the common parts which the landlord may not be in possession and control of, but he has a right of access to inspect and to consider if there are any actionable defects. And that really reinforces a point that I'd like to make in respect of, it's also in relation to the enjoyment issue. And I ask rhetorically, why is a tenant more likely to see a defect in the common parts than a landlord who is specifically, as part of a system of inspection and maintenance, looking specifically for such defects? In our respectful submission, it doesn't follow. We acknowledge that the former cases are of limited assistance because they generally demonstrate that the factual background illustrates that the possession and control was either with the tenant or with the landlord. And in a multi-occupancy block, the issue is not as clear-cut. And so the question becomes, in our respectful submission, where neither the tenant nor the landlord are in possession and control, where, as it were, does the burden lie? Does the court say, well, in those circumstances, the tenant has to give notice and thereby making a further exception to the general rule? Or is the landlord responsible for his repairing obligation without notice in that situation? And that's, in our respectful submission, a balancing act. And we invite the court to look at these matters. The starting point is the wording of the Act, where no notice requirement is identified. And it is a feature of this legislation, in our respectful submission, that when a specific defence is prescribed in section 11.3a, that no attention was given, had it been thought necessary, to absolving a landlord from his repairing obligation where notice had not been given. And the effect of my learned friend for the appellant's submissions is that there should be another exception on top of an exception which has existed at common law and in which the Landlord and Tenant Act has been interpreted for many, many years. And the question, therefore, becomes, is it necessary? Is it workable, the relationship between an intermediate landlord and a tenant, without implying a further exception requiring a tenant to give notice of any defect falling in within the covenant? We say it's entirely workable. The landlord has the wherewithal, either because he is a landlord who is a sole trader perhaps, or just an individual living near to the premises, to be able to inspect whenever he wishes to. If he is far removed, then, as is the case in point, in this particular case, he can employ an agent to do so. And Mr. Kumarasamy had local agents managing this property, as appears from the judgment in the first court. If a landlord does not if a landlord is not in breach of his implied covenant to repair in respect of an actionable defect unless he has notice, then that is a significant disincentive in our respectful submission to inspect and maintain. If he is in a position simply to sit back and wait for the notice to be given to him, then in our respectful submission, there will be no great enthusiasm for him to be doing that which he ought to be doing in order to keep the structure and exterior in repair by arranging periodical inspections. As my Lord Reid suggested, those inspections may not cater for an isolated incident occurring within in the period between one inspection and another, but at the risk of repetition. This is a balancing act, and in our respectful submission, the whole thrust of this legislation was to place the burden on the landlord, and it is not necessary in our respectful submission to adjust that so that the burden rests on the tenant to give notice. Well, Lord, those are the further submissions we would like to make. The issue over section 11.3a and its precise interpretation. The appellant suggests that 11.3a applies and can only apply where the landlord has an estate or interest in a part of the building that requires repair, but doesn't have a sufficient right in it in order to undertake those repairs. In our respectful submission, that is an overly restrictive interpretation, and insofar as it matters for this appeal, we would respectfully suggest that section 11.3a covers both the situation where the landlord has an interest but no right to repair, as in this case, and therefore can make reasonable endeavours of the owner in order to undertake the repairs or get the repairs done. It also applies, and this is supported by the Law Commission's assessment of that particular provision, where the landlord has no estate or interest in the property at all. But it is necessary for him to obtain a right, probably a right of access to a property, in order to undertake works of repair to comply with the covenant to a property affected by the disrepair, in respect of which he does have an estate or interest. The Commission dealt with it in their report at page 503 behind divider 7 at paragraph 5.5. There may be cases where the landlord does not have an estate or interest in the other parts of the building at all, or where, although he does, he may have leased them without reserving a right of access to them, so as to undertake repairs that affect other parts of the building. It is therefore a defence to any action against the landlord for failure to comply with these obligations, firstly, that he has insufficient right in the part of the building or installation concerned to enable him to carry out the necessary work, and two, that he used all reasonable endeavours to obtain such rights as would be adequate to enable him to carry out the work that was unsuccessful. The notion that Mr. Kumarasamy, the appellant, has an absolute defence in this case, leaving aside that it wasn't pleaded, is, in our respectful submission, not to the point at all, because it's accepted that he did not have knowledge, and in those circumstances, if he didn't have knowledge, he would not have obviously be investigating whether or not the repair, whether or not he could obtain sufficient rights in order to undertake the repair. Can I assist the court any further on any particular matter?
Anything? Thank you very much indeed. Thank you, Mr. Benson. Mr. Armstrong. Thank you. Mr. Rainey.
Just very briefly, Lord, there were one or two points which came up. The first point was just a very small point about which came up about what if the tenant hasn't noticed that there is a defect. Well, the point there, of course, is that subsection 1 capital B predicates that liability depends on the tenant's enjoyment of either the dwelling house or the common parts being affected, and therefore, if he hasn't actually noticed anything wrong, it's difficult to see how he'd actually get into this territory at all. So, I'd ask that can be put to one side. Secondly, I completely accept my learned friend's point that if there are reserved rights of access, which there are under 11.6, then equally they would allow him to inspect the common parts. But the point surely there is that they're no more and no less than the same rights he has over the flat. So they don't really take us any further.
If you're right, then there's quite a hole in the statutory scheme if you're right about the word interest. because every time there's a subletting of a flat, there is no protection for the tenant in relation to the common parts, because he's got no claim against the head landlord, because he's got no relationship with that, subtenant. He's got no relationship with the head landlord, has he? Therefore, no claim against him.
You wouldn't have a contractual claim.
No.
In some circumstances, he might have a claim under the Defective Premises Act, but he wouldn't have the simple contractual claim.
No. Whereas if he had a claim against the tenant on notice, as soon as he puts the tenant on notice, the tenant can put the landlord on notice, and all works.
Yes, well, I do say that the scheme works, and one way or another the repairs will get done, or the tenant will obtain damages, because either the head landlord will do the works and the disrepair will be remedied, or the head landlord will not do the works, in which case presumably we'll get to the last resort, and either his intermediate landlord will have to do the works, or you're into the wholesale breach territory.
If the subtenant has a good claim against the tenant, can the tenant visit the claim, get an indemnity from the landlord? Or is that not within the ambit of the landlord's covenant with the tenant?
That would logically, I would suggest, depend on the particular contractual relationship between the...
Well, no, you've got, yes, I see, of course, because the head landlord and tenant would almost always have a contractual relationship outside Section 11.
Yes,
Yeah,
and
right.
that is not constrained by any statutory restrictions on how that can be defined.
So a clever landlord with a building might let each of the flats to a associated company, and that associated company would then grant subtenancies, and he would be free of any liability for the subtenants in relation to under Section 11 in relation to the common parts. Would that be right?
You'd probably have to be quite clever, because it might depend, because of course there are cases in the specific performance field where that kind of thing's been tried with options, and it said, well, no, because you can actually procure in reality that the repairs are done, and so probably you wouldn't be able to fit yourself within Section 3 capital A.
You would have to make it a fairly... Yes, I see. Thank you. Sorry, thank you.
But if what your lordship is suggesting, which is obviously one possible disposition of the case, that the more attractive disposition which makes the statutory scheme coherent would be to reject the argument about interest but to accept the argument on notice, then I would respectfully agree that is...
Well, that does the job as far as you're concerned, so you would, wouldn't you? But it's perfectly fair. That's a fair answer. Sorry, I shouldn't say that.
No, it's an entirely fair assertion to an advocate. So yes, of course I would, but nevertheless the point remains a valid one. I would suggest that the statutory scheme is much more coherent in that way.
But you say, as a matter of language, it simply won't bear that. Interest won't bear that.
I do say that.
Understand.
And logically one has to... The reason I took it first is because although I
Yes.
put the note in the opposite order, logically one has to go there
Of
first.
course. No, quite right. Yeah.
My learned friend then, he did draw your lordship's attention to, I think, two of the older cases to try and
Yes.
effectively knock out the point I was making about Murphy and Hurley and the true nature of the common law rule. But the trouble with trying to do that is that to the extent that he was able to find something to assist him, if you actually look at the rest of the case, you find that actually, as a whole, it doesn't really work, because, for instance, he took your lordship's to the Bishop case, which is one of the early ones, which is at tab 1, and he took you to page 579, page 580.
Yes.
But the trouble is, if one carries on and looks at the right-hand column on page 580, about 3/4 of the way down, there's a reference to Makin's case. In fact, it's easiest to find. If one looks in the left-hand column, you see that being the law, new paragraph. Go over to the right-hand column. You see a passage which begins, on appeal, the divisional court allowed the appeal, which is in Mellison Home. Holding that the principle established by Makin's case had no application where the covenant was concerned not with a part of the demised premises, but with a part of the building outside the demised premises, which the landlord kept under his own control. So you get the 2 points being taken together. So you get the point about the landlord's retention of control. So in my submission, we're back to the same position that we were at the end of my submissions. The Malone friend also tried to base an argument based on what he says is the underlying purpose for the rule. And he referred your lordships to the Law Commission report, which he appended to his note. And the Law Commission undoubtedly gives a justification for the rule. But he then also referred back to Makin, which isn't what the Law Commission said. Now, there are, in fact, a number, if one wants to go into the justifications for the rule, there are, in fact, a number of potential justifications for it. And I don't want to go through them all, but the best place to look for them in my submission is actually in McCarrick. Because McCarrick, possibly because it's in the middle temporarily, in that it's a 1948 decision, it's tab 16. But the references to the long list of justifications for the rule are in the speech of Lord Porter on page 811.
That's right.
And then there's another very useful passage explaining pages 816 and 817, which is Lord Uthwat. And drawing those together, the variations are, it's not that the tenant has the only means of knowledge, it's the tenant has the better means of knowledge. It's peculiar in his ability to find out. Lord Porter emphasises that this sort of disrepairing dwelling houses is effectively a casual thing, by which he means it's not like the seawall in Murphy where you have to watch it every minute of the day in case it erodes. Something like a paving slab is something which might come up, it might not come up. And he says unreasonable to expect daily vigilance for those. He also referred to the strictness of the statutory implied term. And then Lord Uthwat referred to the object being the comfort and needs of the tenant. And then there's I don't think I can paraphrase it, but the long explanation on page 817.
Yes.
And then you get the Law Commission saying, and actually it's unreasonable on the tenant if you keep inspecting his property. So in fact, drawing all those sort of more modern distillations of why we had the notice rule, I would say that they actually support the notion that we should imply the term in the circumstances of the common parts. Yep. They're equally applicable to that on the basis that the intermediate landlord doesn't in fact have the occupation and control of those areas. There was a very small point which arose. Malone and Friend took you to the British Telecom and Sun Life case, and the point was made that actually Lord Justice Norris wasn't really looking at the point with which we're concerned. It's interesting, or perhaps no more than that, but it is interesting that he was referred to Murphy and Hurley, and he said that at page 590 it said it didn't assist him. Well, presumably that's because he wasn't looking at the point we're dealing with.
Yeah.
Because otherwise one would have thought that Murphy and Hurley, which he was referred to at some length by Mr. Radcliffe, would have at least been of some assistance to him. But presumably he was looking at a rather different aspect of the matter.
Yeah.
Subject to what Malone and Friend might say, I think I've only got two very short points left. The first point is Malone and Friend made a submission of law to this effect. He said, if you go back to section 11.3a, he said, even if I'm right, and that there is only a last resort right to repair, he said, effectively, that's enough to count as the right of repair and take you out of section 11.3a. At least that's as I understood his submission, because if your lordships recall, for 11.3a to bite, one has to establish that the lessor doesn't have a sufficient right to carry out the repairs.
Yes.
Now, if what he's saying is that the fact there's a last resort right means I can't satisfy, or that one could not satisfy 3AC, then I would respectfully disagree. If that section's to work coherently, it must mean that you have the right to do it at the point at which you are the defendant. That if proceedings are brought, you have a defence. So at that point, you must be able to say, well, I've given notice to my landlord, you've jumped the gun, you know, there's a Section 20 consultation procedure in progress, I'm not liable yet.
Yeah, I've done all I can.
I've done all I can, at least for the moment. And if in due course repairs are still not done, you may fall out of Section 3A. But if you can demonstrate reasonable endeavours at the point you're sued, then in my submission you must have a defence.
Yes,
So I'd respectfully disagree with that submission. And I think finally, my learned friend asked a rhetorical question. Why ought your lordships to think that the tenant is more likely to see a defect than a landlord who might be inspecting with his agents? And the answer is very simple. If the tenant's going up and down the common hallway and out to the bins every day of the week, well, not every day of the week with the bins, but going in and out of the building constantly, actually, yes, he is much more likely to spot the defect than even a competent managing agent on a regular but infrequent inspection. Unless there's anything further with which I can assist you, that's all I have to say in reply.
Thank you, Mr. Rainey. Well, thank you very much, Mr. Rainey, Mr. Benson, for your oral submissions, and thanks to everyone involved in preparing the written cases. We will consider this matter and let you know our decision in due course. Thank you very much. Court's now adjourned.